Welcome to this Law for Community Worker webinar, Family Law Property Basics. I'd like to start by acknowledging the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the lands of the Widjabul-Waiable people of the Bundjalung Nation. Matilda and I pay our respects to the elders of the land, both past and present, and we extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. The session will be an hour in total, including time for questions and answers at the end. After the webinar, you will receive a survey, and we do appreciate your feedback and suggestions for other topics you'd like us to run webinars on. I'll now hand over to Matilda, who will be speaking to you today about property basics. I'm just handing the control over to Matilda. Thanks, Matilda.
Thanks, Bridget. Good morning, everyone, and thank you for joining us this morning. My name is Matilda and I'm in the SWAT family law team at Legal Aid, and SWAT is the statewide advice telephone service. We basically give advice on the telephone, and anyone can call seeking that one-off advice. So I'll give our number at the end, I believe, for anyone that you'd like to pass that on to. And yeah, it's basically a one-off service that people can get kind of general advice, and we help steer people in the right direction, whether that's within legal aid or to outside assistance. So it's a very helpful service there. And I've been a solicitor for about 15 years and have a fair bit of experience with property settlements. So hopefully I can shine a bit of light on that for you all today. Now, let me see if I can work this. No, Bridget, I might get you to move to the next slide if you don't mind. Thank you. So when we, I'm sure when you basically come to dealing with a property settlement yourself, or having clients come to you or people come to you that you need to assist, generally, you know, the start of a situation is where a relationship ends. And there might be a number of things that need to be dealt with as a result of that relationship ending. If there's children involved, then parenting arrangements may need to be put in place, and that's separate from property and divorce. Parenting arrangements can be made at any time, and that's usually about where, you know, a child is to live or children are to live, and, you know, how much time they spend with the other parent. Two other things that a couple may need to work through is a property settlement, where that's essentially dividing the property between the parties, and a divorce. So for people that are married, they can apply for a divorce once there's been 12 months of separation. Some people may choose to get divorced. They may not choose to get divorced. It doesn't necessarily matter unless you're going to get remarried, in which case you do need a divorce. But they're all very separate things. There is a little bit of interaction between a property settlement and a divorce that I'll cover later down the track, but essentially the divorce, if you apply for one after 12 months of separation, it won't deal with property, it won't deal with parenting matters. They're separate things that need to be dealt with. Okay, so when we talk about, when we talk about property, it includes all property. So a lot of the time people are just focused on the house that they own or that one person owns and how that's to be divided. But when we're making property settlement orders or we're asking the court to determine a matter, the court will look at all of the property, and that will include the house, the land, apartment, investment properties, businesses or companies, cars, motorbikes, caravans, superannuation shares, unfortunately, pets fall into the property category and will be valued as such. The court doesn't enter into custody arrangements for pets, sadly, and furniture and household items, jewellery and cash. In terms of how we value those things, sometimes for houses, land, you might need a real estate agent to come in and give a bit of an idea as to market value. Or you get a couple of real estate agents in to do a bit of an appraisal. If there is a real dispute, then you might engage an actual real estate valuer to give a value. Same with businesses or companies, they are a little bit more complicated and sometimes need an expert valuer to value those businesses. With like furniture and household items, jewellery, they're really what you would get on the secondhand market, and essentially, you know, maybe Facebook Marketplace. How much would you be able to sell your mattress for, your bed? Usually not too much. So, and jewellery also doesn't really have a great secondhand value. So sometimes people come to us and say, oh, I've got $40,000 worth of property and like possessions in the house, and you think, okay, well, you know, is there artwork in there? Is there really expensive jewellery in there? Because normally I don't think most people would be able to sell all of their stuff for, you know, that amount on Facebook Marketplace here and there. So that's something to keep in mind. And when we talk about debts, obviously it's mortgages, personal loans, buy now, pay later debts like Afterpay, car loans and leases, credit card debt, unpaid tax, household bills. Also HEX is one that comes up a lot. With personal loans, something I guess to keep an eye on is, you know, at the end of a relationship, some people will say, oh, you know, that money mum and dad gave us 10 years ago, that's a loan that I have to pay back now. You know, so it's always a bit of a tricky one when people create loans. That can be a bit of a cause for dispute. So I think my recommendation with any loans is that if they are genuine loans at the time they're being made, particularly with family, get it legally documented so that everyone's clear from the get-go whether something is a loan or a gift. Now, who can enter into property settlement, you know, legally binding property settlement documents? Because essentially, the advice is usually that you should legally document any property settlement agreement. And if the court is being asked to make property settlement orders or determine a property settlement matter, there's certain categories of people that are allowed to apply to do that. And married couples are one of them, or divorced couples. Put a caveat on that, but when you're married still, you can apply for a property settlement, and de facto couples. So when the court determines whether a couple is a de facto couple or not, they look at a few things. The three main ones are that the couple is not legally married, they're not related by family, and they live together on a genuine domestic basis. And whether it's appropriate or not for the court to make these orders for a de facto relationship, they further look at relationships that have been had a total of 2 years duration at least, or if there's a child of the relationship, or if the applicant has made substantial contributions to the asset pool, and the failure to make orders would result in it not being just and equitable, or if the de facto relationship was registered. So there's a number of criteria that the court looks at in saying, you know, whether or not there is a de facto relationship, because there's sometimes some grey areas. It might be that somebody was having an extramarital affair with somebody for over 2 years, but then it's a question of, okay, you've been in a relationship for 2 years. Is that actually a de facto relationship? And you can have a de facto relationship while still being married to somebody else. It's, I guess, about you know, the aspects of the relationship. And sometimes the court will look at even more specific things, like what was the public aspects of the relationship? You know, were you invited places together as a couple? Did you put out to the world that you were a couple, or at least to part of the world. You know, was there a sexual relationship? Was there a shared commitment to a life, a mutual commitment to a shared life together, that type of thing. So sometimes when we look at de facto couples, it's easy. Other times, you know, there's a bit of we've got to drill down into the specifics of the nature of the relationship to see whether it was a genuine de facto relationship and whether the court would deem it as such. And when applying to the court for property settlement orders, there also has to be a geographical connection to Australia. So one of the parties is ordinarily resident in Australia, or was when the relationship broke down, that at least a third of the relationship occurred in Australia, and that, yeah, basically, you know, if you've been in Australia or Australian resident for a period of time, then you'll be eligible. That there says that, you know, you've resided in all states of Australia except for WA. WA has its own Family Law Act that very much mirrors the Family Law Act that the rest of Australia follows. But they tend to hive off and do their own thing. So if you've got a connection to WA, that could complicate things slightly, but not too much. I think somebody who registered asked a question about being in Queensland. That's fine. If you're Queensland, New South Wales, any of the other states other than WA, you all fall under the one Family Law Act. Okay, so basically when people first separate and they think, okay, we probably need to have a property settlement, the best thing that they can do, if it's safe to do so, is to negotiate with each other or have a discussion with each other about, okay, what do we think is just and equitable to divide our property? If there is an agreement, then one party could go to a solicitor. Essentially, a solicitor can't see both parties, they can only see one. So, but where people are on the same page, you know, there's an agreement, it's not too complicated. One person could go off to a solicitor to get it drafted, then it's signed up and sent to the court to be made legally binding. There is an app available now that the South Australian government, I believe, created. It's called Amica, AMICA. And I think if you pay, it might be $250, and you plug in what your assets are, what the agreement is, that will actually generate the property orders for you that can then be sent off to the court to be made legally binding. That's probably a good option for people that don't have a couple of $1,000s to spend on a solicitor to draft up the agreement. So yeah, you know, that's something that you could possibly inform people about. So there's two ways that property settlements can become legally binding. One is the consent orders that I just spoke about, and the other one is a binding financial agreement. So a binding financial agreement is where two parties enter into a private contract that doesn't go before the court, but it has the effect of being a legally binding agreement. And the legally binding nature comes from the agreement being properly drafted and both parties having received independent legal advice. So both parties have to get their own solicitor for that. And, you know, we tend to see that in, you know, agreements where there's probably a lot more, you know, higher assets, higher net worth, because they can be a little bit expensive to draft and both parties have to pay their lawyers. So the common way to do it is through consent orders that get sent to the court to be made legally binding. So that's if there's an agreement. If there is no agreement between the parties, then a next step for them might be, okay, we'll go off and get solicitors, and then the solicitors will try and negotiate between each other, or maybe they'll go to mediation first and try and mediate an agreement. And if that fails, maybe then they get solicitors, or, you know, maybe they think about, okay, I can't afford a solicitor and I'm maybe not eligible for legal aid. I've got to now make an application to the court. And of course, if they're possibly eligible for legal aid, then of course, they can come to us and we can assess whether they're eligible or not. So yeah, once you're kind of moving along that legal pathway, the solicitors will try and negotiate, or again, you'll try and negotiate through mediation. If that fails, you think, okay, now we've got to go to court. Either party can apply to the court for the orders, but there's got to be some pre-action procedures kind of ticked off before they go to court. And one of them is a full and frank financial disclosure. So that's where there may be exchanges of financial documents between the parties. Might be the last 12 months of bank statements, maybe last 3 years of tax returns, superannuation statements, maybe, car valuations. There's a website called Redbook that gives good indications of what cars are worth on the second-hand market, that kind of thing. So that both parties are basically across each other's financials and they know what the other party has. And that's particularly important where maybe one party or both parties have separate bank accounts, or, one person was in control of all of the finances and the other person didn't have access and doesn't know really what is going on. And sometimes in those bank statements, you'll see, okay, the husband has a separate account that he's, been buying shares with. And so the shares would then form a part of the property settlement. Or, the husband has got a gambling addiction and, he's blowing through money like nobody's business. So, that might come into play. But once there's been a full and frank financial disclosure, then that's satisfied part of the pre-action procedure. Sometimes when you go to court, you haven't received all of the documents that you would like to, and that's when you can ask the court for a subpoena or something like that to the other party's bank to try and get those records if the other party hasn't been forthcoming about providing those documents. The other pre-action procedure is dispute resolution. So if you haven't done mediation already, you've got to offer mediation and attempt to attend mediation to try and resolve the dispute. And if that doesn't work and you're thinking, okay, yep, we're definitely going to court, you've got to write to the other party to put on a formal offer of settlement. So, I want the house to be sold and, I receive X, you receive Y, whatever the case may be. And advise them that if the offer is not accepted, that it is your intention to apply to the court. So you've put on an offer, they're aware that you're going to file if the offer isn't accepted, and then you can apply to the court for property orders. There are some exemptions to the pre-action procedures. One of them might be urgency. So for example, just say the house is in the husband's name only and he is going to sell the house, and the wife knows that the husband is a chronic gambler and that he will probably gamble away the money as soon as it comes into his hands, and that's the main asset. There would be some urgency to that type of application, and you could skip the financial disclosure, dispute resolution, and go straight to court to seek like an injunction, essentially. So that's kind of the pathway to court. Now, if you do apply to the court, they basically they take into account 4 steps when trying to determine who gets what. The first step is it just inequitable to make some orders? And that's where your questions about, de facto relationship might be raised. One person might say, well, I don't think that orders should be made because there is no de facto relationships. And so this is a stage where you might have those arguments. But just say the court says, look, yes, it's a married couple, they've got property, joint assets and what have you. It's appropriate to make some orders here. What kind of orders are we going to make? The second step is what contributions of a financial and non-financial nature have the parties made to the asset pool. And, we'll look back at what did they both come into the relationship with. It might be, a couple that got together when they were very young and they've been together for 20 years and, they had nothing at the start, and everything that they've got now they built together. And even if that's the case where, you know, just say dad went off, the husband went off and worked full time throughout the relationship and was earning the income, and the wife stayed at home and had the children, raised the children, looked after the home. If those are really the only contributions at play, that would be seen as fairly equal. Even if the husband was earning $1 million a year and the wife was stay at home, he wouldn't get any extra points in a sense because he made a lot of money. The court looks at those kind of contributions as everyone doing their part, and it was a joint decision that, yep, the husband's going off to make this money because wife's at home looking after everything else. So there's really no distinction there in contributions. The times when you move away from looking at contributions in an equal sense is if there has been clear contributions from one side only. So it might be an inheritance that's come in from one side, or someone's parents gifted them money along the way, or maybe it's a second marriage for one of the parties and they've come into the relationship with more assets than the other. That's when we start to look at disparities in contributions, for example. So the court will say, okay, what do we think it is percentage-wise on contributions? And just say it's 50-50. Yep, okay, they came in with nothing. They both built what they had. No inheritances, no gifts. Probably we're looking at 50-50 on contributions. The next step the last step would be essentially, what are the future needs? And future needs are basically the ability of each party to support themselves from income moving forward. So, in that kind of situation where you've got more of a traditional marriage where the husband's gone off and worked, he continues to have the same job, his career progressed throughout the relationship, the divorce, the relationship breakdown is not going to affect his earning capacity. But then on the other hand, you've got the wife who maybe has been out of the workforce for 20 years, doesn't have a source of income, and still has the primary care of children, who is going to impact her ability to work as well, So that's where the court will do some kind of adjustment on a percentage basis to, I guess, compensate in a way the disparity in earnings because of the position that one party is in because of the nature of the relationship. And so overall the court will come up with an overall percentage. It might be 60-40, could be 70-30, 50-50, or all different percentage outcomes that you could think of, depending on all of those factors. That's kind of the process that the court takes into account there. Identify the assets, assess the contributions of the parties, adjust for the parties' future needs, decide whether it's just equitable, except that step 4 is now actually step 1 due to a case that happened quite some time ago. So this is a sample balance sheet that we would do at the outset of, what are the assets and liabilities, and it doesn't matter whether an asset is in one name or another. It all goes on the balance sheet, and it also doesn't matter whether something was purchased or sold, well, not sold, but purchased after the separation. So just say there was $20,000 in savings and the wife went off and purchased a car for $20,000 and it's in her name and she bought that after the separation, that still goes on the balance sheet. So you've got the assets there, the liabilities, credit card, home loan, and then superannuation. And superannuation is included as an asset. So this is a like a case study of kind of around that same type of case that I, explained earlier, where you've got a very typical type of traditional type of relationship. So you've got Trina and John, 20-year relationship, children are aged 17, 15 and 13. They bought a home together after they got married, combined their finances. John worked full-time throughout the relationship. Trina took some time out of the workforce after the birth of the children, and Trina is the primary caregiver for the children, and they're their assets. You know, in this kind of case, and it's not an exact science, but, you know, when lawyers are giving advice on what they think are the possible outcomes, you'd probably be saying this is possibly a 50-50 to 60-40 case, where it might be 50-50 on contributions, but Trina gets a little bit more because of those future need issues. You know, she might only get 5% because the court will say, well, the kids are old enough where she's able to work full time a bit more easily than, say, if the kids were 7, 5 and 3, then she might be looking for a greater future needs adjustment of maybe 10 to 15%. So you could even be saying maybe Trina, if the kids were a lot younger, could be looking at maybe 65%. Just to take into account the fact that she's got the burden of primary care for young children that's going to impact her earning capacity. And then, you know, the court ultimately has to say how that 50-50 falls. So, you know, does the family home need to be sold? Is there going to be a super split? So you can, the court would probably give some of John's super to Trina to make up that percentage outcome. Here's another one that's a bit different. This is Sophia and Luca, and the length of the relationship is 3 years and they don't have any children, and they're in a de facto relationship. So they both work full time throughout the relationship. They rented a unit together, contributed equally to utilities and other living expenses, kept their own bank accounts, each paid all expenses for their own investment property. So it's a short relationship. We'd consider 3 years to be a fairly short relationship. And they're both on very similar footing. They've both got a property that's worth similar amounts. They've both got cars that are fairly similar savings, similar furnishings and effects, and fairly similar super. And they've both pretty much come into the relationship with these things. They haven't purchased anything together. You know, it's up to them what they want to do. They might agree, you know, let's just take what we both have in our names. There's nothing to untangle here. We both kept things very separate, and there's no need for a formal property settlement. We're just going to, you know, separate and move on. They may want to enter into some orders just for that extra protection, because essentially when you enter into property settlement orders, it stops one of the parties from coming back later down the track to apply for a property settlement. So I think if I was advising these or one of these people, I would be saying, if you're on good terms, there's no kind of discussions around, you know, one person having to pay the other out, you may as well just, you know, have a clean break, protect yourself, make it legally binding, and then, you know, walk away from each other. You know, the situation might be slightly different if, for example, Luca didn't work for 1.5 years and Sophia was financially supporting Luca and helping him pay his mortgage and, you know, contributing to his expenses while he was, you know, say setting up a business or something like that. You know, that's where you might say, okay, well, Sophia has made the greater financial contribution and maybe she should be paid some money to reflect that she's made the greater financial contribution. It wouldn't be dollar for dollar. The court doesn't normally do a dollar for dollar. So just say she financially contributed to him to the tune of $50,000. The court may not necessarily say, okay, you get that $50,000 back. It would be some kind of percentage increase to her. She might get, 53% as opposed to 55%, and whatever 53% equals is what she gets. So yeah, it just really depends on the circumstances and facts for each situation as to how the court will, reach their outcome. So something that is separate to property settlement is spousal and de facto maintenance. Spousal maintenance and de facto maintenance is essentially where one party doesn't have the capacity to support themselves from income and meet their own needs, and the other party has the ability to pay maintenance. At legal aid, we often don't see too much spousal maintenance. Essentially, when parties separate, it puts a real financial strain on them because, they go from combining assets and resources and income to help pay for things to suddenly having to pay for perhaps two properties. One person might move out and start renting, but then they've still got the mortgage to pay on the other property, and things are a bit tight. So we tend to really see spousal maintenance when there is someone who has an income to comfortably live on their own and also comfortably help financially support the other person who doesn't have the ability to support themselves. I'll just go back to spousal maintenance. So spousal maintenance generally can only be enforced if there's an application to the court. It's something that you can negotiate, of course, at the outset of a separation, but most people won't agree to it, and it's something that you have to kind of make an application to the court for, and it can be expensive because you have to go through that process of proving that you can't support yourself and proving that the other person has the ability to support you. And the court will make orders for probably a shorter amount of time, like it might be a year or two. It's not usually an ongoing thing. And the purpose is to assist the other party to help to get back on their feet. So, the matters where I've done spousal maintenance is where you have, say, a high income earning husband. Wife has been out of the workforce for 20 years and, her only way of earning an income might be from Centrelink or from, getting a very low level job. And so, there's an application there for the husband to continue to pay the wife and help her meet her living expenses while she might retrain or do something to help her get a better job. So yeah, that's spousal maintenance. Now, there are time limits for applying for property orders. So when I said before that divorce and property settlement are two separate things, that is correct. Property settlement deals with the property and divorce ends the legal marriage. But there is a slight intersection because of time limits. So when a married couple separate, they can do their property settlement at any time and apply to the court at any time for property orders as long as the pre-action procedures are kind of ticked off. If, however, they apply for a divorce, which they can apply for 1 year after separation, 12 months after separation, and that divorce is then granted by the court, if they still haven't done their property settlement by that point, the clock starts. So from the date that the divorce comes into effect, they've got 12 months to either apply to the court for a property settlement, basically saying to the court, okay, we haven't been able to figure this out, we now need the court's intervention, or to otherwise file those consent orders to say, okay, we have come to an agreement, here are our orders, we would like the court to make those orders legally binding for us. So my advice is often to do the divorce as a final wrap up, because you don't want to invoke that time limit and start the clock too prematurely. There are some scenarios where you do want the clock to start as a strategy, but in most cases we say, look, do your property settlement first, give yourself the time to do that, and then once that's done, just do the divorce as a final wrap up at the end. For de facto couples, because there is no divorce, they've got 2 years from the date of separation to make their application to the court for property settlement or to otherwise file those consent orders. So for de facto couples, it's important to kind of keep an eye on when was the actual separation. And same for married couples, because if they're applying for a divorce, they need to have an actual date in mind of when they separated. And sometimes for people that can be a bit blurry, you know. Sometimes I'll say, well, we haven't been sleeping in the same bed for a long time or for years. And, you know, maybe we've already been separated for years. But when we look at separation, the court generally looks at the date that really it was communicated by one person to the other to say the relationship is over now. You know, when was the time that you started to tell the kids that, you know, the marriage was over, or tell your friends and family that the marriage was over, and really start to live separate lives. So it's always good to keep a bit of a record of the date that somebody thinks that occurred. We also encourage people to enter into consent orders to make their property settlements legally binding, just in case there's an issue with enforcement. So normally property orders, just say there's a house involved, it'll say the parties, within 7 days of the date of these orders, the parties are to engage a real estate agent and place the property on the market for sale or something like that. And it'll have various mechanisms in place for that to occur. And if somebody doesn't comply with that agreement, then you can go to the court and make an application for a breach and for enforcement, to basically enforce the orders. So if somebody agreed to sell the house and, you know, all of that, but then when it comes time to sign the real estate agent contract and they refuse, you can go back to the court and say, well, they're refusing to uphold their end of the bargain, and the court can put orders in place to ensure that the house is sold, that the agency agreement is signed, etc. So they're good to fall back on in case there's any issue down the track with an agreement. And these are some helpful resources that you can give to people or use yourself. The Attorney General's Department has, you know, a good guide and an example of what consent orders look like. The Federal Circuit Court and Family Court of Australia also gives a bit of an overview there, as well as legal aid. That one says works out what's best for kids, but that we also do have property settlement links. And this is the Amica website that I was talking about before that does those consent orders for a fee. And I think if people are on Centrelink, that fee is reduced or maybe even waived to get those kind of free orders. They also do parenting orders, but, you know, I haven't actually used them. So, and a colleague said that she was a bit iffy about the parenting orders, just in terms of the, you know, people not getting legal advice about whether the orders are in children's best interests or not, because it just kind of pumps out what people put in. We'd probably recommend that people get some legal advice before they enter into any orders anyway. And they can get that legal advice through Law Access New South Wales, which the number is there for anyone, and then they would come through to our SWAT team for that telephone legal advice. Or people are welcome to call, you know, if there's domestic violence involved, the domestic violence unit within legal aid, or community legal centres and local offices. I've finished a little bit ahead of time, and I saw that in the response when you all registered that there were a couple of questions that I wrote down. So I'll answer those, and certainly if there are any questions in the Q&A, I can get to those as well. So somebody asked about like a prolonged settlement. So it was a bit of a complex question just regarding, you know, to do with child maintenance and that kind of thing. But I guess the main issue with property orders is that people often want to delay entering into property orders to sell property. And you particularly see that when kind of what's going on now, where property prices have dropped significantly, and they're like, well, we do want to sell the house, but we don't want to do it just yet because of property prices, or I want to live in the house for the next 5 years until the kids are a little bit older and then I'll sell it. That's all well and good. You can do that. It's just that to enter into consent orders, you really do need to be entering into an agreement that ends the financial relationship pretty much immediately. The court also has an obligation to end the financial relationship between parties and provide a clean break. And where you're continuing to hold on to a home together for 5 years, things can get a bit more complicated down the track. You know, people might start making a lot more contributions, and, you know, the percentage outcomes should then change. Property prices might go up a lot or down a lot. You know, so we always say that it might be slightly difficult for the court to make orders that provide for that type of agreement. So always get some legal advice about that. So that's that. Somebody also asked about being out of time. So just say you've gotten that divorce, 12 months have passed, you still haven't dealt with your property settlement, but effectively you need the court's intervention to deal with the dispute. Basically, you can apply to the court, or same with the de facto, just say 2 years have expired, it's now 3 years since you separated and now you're going to do the property settlement. You can apply to the court, but you have to basically ask the court for special permission to apply in the first instance, and you need basically a grant of leave to apply. And the court would be looking at, okay, is it just inequitable to make these orders out of time? And, you know, where there's still joint property, there might still be a house in both names. The court's probably more likely to say, okay, we'll deal with it out of time, than a situation where, like Sophia and Luca in that case study, where there are no joint assets. If the court looks at it and says, well, you're out of time and there's actually nothing we need to untangle, then, you know, you're possibly looking at the court saying, no, we're not going to hear this case. So it's always very important to keep an eye on the time limits and get in before the time limits, because you're at the court's mercy as to whether the court deals with it or not. Now, there were a couple of questions here. What if one partner spends a whole lot of money on non-tangible items, i.e. overseas holidays after they separate, or accrues a lot of credit card debt? Is the asset pool balance taken at the date of separation or date of settlement? So the court can actually choose when to kind of draw a line in the sand and deal with the asset pool. Normally it is the asset pool at the time of the final hearing, the trial. And if there has been a lot of expenditure, like credit card debt would go on to the liability side and attributed to the husband. And essentially, I think you'd be arguing that the court would make the order that the husband keeps that credit card debt. whether it's included or not in the overall percentage. You know, they might just siphon it off and say, no, that's his debt, we're not going to include it. But in the overall asset pool. And same with expenditure, they can actually add back the money back in. So even though it's already been spent, they'll say, well, he's had the benefit of that money, and we're going to take it into account as if that money was there today. It's really up to the court to, you know, make the final decision as to how they deal with certain things, but you could definitely make those arguments as to like waste, essentially. What if a divorce has happened but one party is holding up the property settlement process on purpose, i.e. not disclosing info, not showing up to court dates? So if the divorce has already happened and kind of coming towards the end of that time limit, I would say just file, get your foot in the door at the court so you're not, you know, kind of passing that time limit. Even if there hasn't been a full and frank financial disclosure, because once you're at court, that's when you can start subpoenaing banks or employers or whatever to get that information. There are a lot of occasions where people do not make a full and frank financial disclosure at the time of filing. If they're not showing up to court dates and you're already in court, well, the court will, you know, deal with them appropriately, and probably if they're not going to engage in proceedings, then they're at a big disadvantage because the court might, you know, completely side with you and make the orders that you're seeking. A tax debt in one person's name. So same thing. It depends on how the tax debt was acquired. Generally, if it was, say, from income during the marriage, and there's a tax debt, well, just say it's the husband who's got the tax debt. He might say, well, yeah, I've got this tax debt because I spent all of my income on, just say it's a PYG situation, all of the income on the family, and I didn't have enough money to set aside for tax, and therefore that tax debt is really like joint tax debt because I spent all the money on family expenses. If the husband then really kind of gambled all the money away and didn't put away money for tax debt, then the court might say, well, sorry, buddy, this is your tax debt because you should have paid it at the time and you didn't because you essentially wasted the income. So it really just depends on the circumstances of how debt arose. I think that's probably, oh, another question there. What if the consent order has been drafted and the one property in question has changed value 7 months later? Yep. Yep. Okay, so sorry, I'll read that out. What if the consent orders are being drafted and the one property in question has changed value 7 months later when they are drafting the consent orders, but the amount was originally agreed to 7 months ago? Can the other side change it, thereby delaying the consent order process as it is a new negotiation? Yep, definitely. You know, this is the issue sometimes with, I mean, you would hope that consent orders don't take 7 months to be drafted, but it seems like they are in this case. You know, the idea is that really once there is an agreement, the consent orders are drafted quite quickly to avoid this type of situation. But until the consent orders are made legally binding by the court, they're not legally binding and you can renege on any agreement. So if you go to mediation and you agreed to something, but then after the mediation you think, no, I was pushed into that position, I shouldn't have agreed to that, you can renege. Even if you've got the consent orders in front of you, it's all agreed, it's time to sign, you can renege. Even if you've signed it and they've been sent to the court but haven't been made yet by the court, you can renege. It's a bit harder. You need to get in quickly before the court rubber stamps the orders. But yeah, essentially you can renegotiate anything at any point until those orders are made. So that would be my advice, to definitely renegotiate. And that's the thing, the current property market is really putting a spanner in the works for people, even just in terms of trying to refinance. You know, people that thought, okay, yep, I can refinance and I'll pay out, you know, my X amount of money. And then they go to the bank and the bank says, sorry, interest rates have gone up. No, we're not able to lend you that much. So that's the other tip. If anyone is entering into orders where they're going to refinance, make sure you get the pre-approval from the bank before you enter into those, before you sign off on the consent orders, because you want to make sure that you can actually refinance. Can we ask for costs? You can ask for costs if a matter runs to a final hearing. Anytime before that, you know, it's a part of the negotiation process, really. But the costs are usually only ordered where it runs to a final hearing, the judge is making a decision, and just say the judge awards the wife 60%. But 6 months ago, the wife actually made an offer in writing to the husband that said, I'll agree to 50-50. In that case, the court would probably order costs against the husband because he's dragged all of this out and he's actually ended up in a worse off position than if he just took the offer that was originally offered. And so he's wasted everyone's time and resources. So they're the types of situations that you see costs. But generally, as a rule, and as the legislation says, that everyone is to pay their own costs unless there is, you know, circumstances like that. Any other questions? Nope. Well, hopefully I've covered all of the basics there. The slides will be made available, I believe, after this, and a recording of me talking very fast at you about all of the things that are property settlements. So yeah, I hope you all got something out of it and wish you all the best of luck in case you're going through it now.
Thanks,
yourselves.
Matilda. Just to let people know before we end that I did upload the handout into the chat. I know people can't use the chat to ask their questions, but I have uploaded it there, but I will also email it to people. And I'll also include in that email the links to the resources that you referred to on those last couple of slides, so people can get access to those. And I think there's a question about would there be a session on prenups and trusts? That's something we'll discuss and see if we can provide that. It's great to get that kind of feedback.
I typed an answer just there. I would say probably not, only because legal aid don't advise on prenups.
Right.
And trusts are tricky. So if you're dealing with those kind of issues, we would definitely recommend going to a private solicitor, because legal aid don't really deal with those kind of things.
That's great. You're onto it ahead of me. Thanks, Matilda. So I wanted to thank everybody for joining us today, and thank you, Matilda, for a really interesting and informative presentation. And if anything else occurs to you after we close off, then please feel free to email us. Oh, sorry, there's one more, Matilda. How can we speed up the other side to finish drafting the consent orders?
If a solicitor on the other side is drafting the consent orders, I guess it's just a matter of writing to them and trying to put pressure on them to say, you know, we agreed to this agreement X number of months ago. Can we please have these? Alternatively, you can get your own drafted and just say, here, I've got them. You know, I'm not waiting on you to draft them. But sometimes it is an issue of negotiating the terms back and forth, and sometimes it might just have to be a question of drawing a line in the sand and saying, you know, I'll just accept the terms as is to get this happening, you know, if you're in a position to do that. So otherwise, if you can threaten court proceedings, and not in a nasty way, you just say, listen, if you are not going to present these consent orders, we've been waiting months, and I'm going to file. And that generally gives people a bit of a kick in the butt because nobody wants to go to court.
Okay, some thank yous coming through. Thanks very much, Matilda. And the recording, we'll send a link to the recording in the email that you receive following the webinar as well. So we'll end the webinar now. And thank you everybody for attending. And thanks again, Matilda.
Thank you all.
Bye
Bye.
everybody.